State of Oregon versus Joy Graves, case 16-09 for 18. And I do see that there's motions, is the state ready to proceed in this case?
Yes, sir.
All right, and I understand, Mr. Talmadge, you are not, and Ms. Graves, well, I shouldn't say you are not, but in light of the motion, that Ms. Graves filed on her own, that you would like to be withdraw as counsel.
That is correct, Your Honor. That's Ms. Graves' continued position regarding some of those issues. I did have the opportunity to speak with Ms. Graves out in the hallway today. You know, I think that there is a fundamental disagreement between me and Ms. Graves as to how this case should be approached. And I don't want to get into too much of it, but here's what I propose. I think we need to hear the Parton motion first, but if Parton is the higher priority case and is going to go today, if Ms. Graves is willing to have me as her attorney going forward, her issue appears to be that she wants to be heard on these motions that I don't believe or did not believe would be successful. I think that people want to be heard. She's also having a lot of issues this morning and related to anxiety because these motions haven't been heard, I think. And I propose we set a date for a hearing and we just hear these motions. And the court can make a decision and then she can decide from that point how she wishes to proceed. There's 4 motions pending before the court.
What are, and I'm sorry, maybe I missed that.
They're motions that Ms. Graves filed on her own. 2 of them are motions in limine related to the state's evidence of the lab report that cannabis metabolites are not evidence of intoxication, which we know that. I usually get the state's expert to say that on the stand, so I don't, that's one of the disagreements we have, but I don't want to get into too much attorney-client privilege stuff, but you know, there's a motion limiting for that. There's a motion regarding this assertion that religious freedom checks the state's ability to regulate cannabis intoxication. There's a motion to dismiss for the statute of limitations because there was a delay in bringing this case to prosecution, although that was partly due to the fact that Ms. Graves had a failure to appear that was not charged in this case. But that being said, there is a motion for that as well. And so if the Parton case is going to move forward today, then, and Ms. Graves is willing to have me as her attorney, then I say, you know, after speaking with her in the hallway and seeing how upset she is, then I say let's have a hearing and we can argue these motions and the court can make its ruling.
Yes.
We addressed these motions on December the 7th, 2020. And what counsel has just iterated is essentially he does not think these motions are meritorious. Obviously, he cannot file motions that he knows are not meritorious. It's against his ethical responsibilities as an attorney. I understand that Ms. Graves may be unhappy about this, but that is the state of the practice of law. The client is not necessarily happy with their defense attorney or their attorney generally. It is not a issue that we need to be deciding if Mr. Talmadge is unwilling to actually file these motions because he knows that they're not proper.
Thank you. So hang on just a second. So, Ms. Graves, are you wanting to represent yourself?
I feel like I'm being constructively deprived of my 5th and 6th Amendment, Your Honor. I'm not having communication steadily. We haven't met even when you instructed us to sit down and go over those motions. That has not been accomplished, Your Honor.
So my question is do you want to represent yourself?
I would like to have counsel that will effectively represent me.
So let's have a conversation about that. Mr. Talmadge, how long have you been an attorney?
Approximately. This year will be my 20th anniversary, and actually in October will be my 20th anniversary of being passing the Oregon State Bar and being sworn in as an attorney.
How many trials have you done?
Jury trials probably close to 60, non-jury trials, bench trials like divorces and arbitrations, several hundred, I've also done, countless, evidentiary hearings, probably over 1,000 evidentiary hearings, I would say, over my, well, I don't, I mean, but at least over 500 evidentiary hearings over my career, because I've been a litigator my entire career.
Ms. Graves, Mr. Talmadge is one of the attorneys on the defense consortium that brings novel legal arguments to this court all the time. He is compassionate and caring with his clients, and he's a hard worker and dedicated. I see that every day when he appears. And so I could go ahead and appoint somebody else. I mean, that's within my power. But I don't know that you're going to be happy. I really have to see if there's a real and true conflict. I read your motion, and I will tell you, the court has overworked Mr. Talmadge. The court has overworked Mr. McCahill. The court has overworked Gail, my judicial assistant, and so therefore you're not going to escape that with any attorney that I appoint. We are overworked right now. And he is absolutely correct that he's juggling 2 cases today. So is Mr. McCahill that's going to go to trial. You're not going to escape that or avoid it. And I don't doubt that he puts the attention needed to cases. And Mr. McCahill is absolutely correct in regards to him not filing things that he believes that if he does not believe they're meritorious, that he cannot file them. And so he can have a discussion with you. But I assume that, I mean, do you have legal training?
Not formal, no.
Not formal. Okay. How much informal legal training do you have?
I was declared an expert witness by Grant County District Attorney regarding cannabis. I've also asked for a couple different expert witnesses that would be crucial to my defense to be contacted. For 2 years, they haven't been contacted. Most of the emails, the phone calls, the messages I've left have not been returned. I appreciate that the court sees Mr. Talmadge a hard worker, and I'm not suggesting that overall he's not, but what I'm saying is I have not had communication. I have not been apprised. I have not been heard. Even when you ordered us in December to sit down and go over these motions, he said on the record he believed that some of my motions would be sustained if they were heard. That's why you gave an extension.
That's different than what you put in regards to your pleading that it had merit. That means maybe he has the legal ability. If it has merit, he can present it to the court. Doesn't mean that it'll be sustained. Doesn't
Right.
mean that you'll get your motion.
No, I
It just means-
understand that, but if he told the court he felt some of them might have merit, you gave an extension for us to go over them. That was not done.
So, Mr. Talmadge, did you make an opportunity to discuss the motions with your client?
I've had several appointments with her. I don't know that we actually talked again about the motions, but we've had several appointments on the phone where I've spent several hours with Ms. Graves. I've also retained an expert of my own, and I explained that to Ms. Graves, and I used that expert to prepare for trial today. And I've shown Ms. Graves my work product, which is extensive in preparation for this trial. It is not. But as far as the motions go, I suppose we could have done a better job of talking about the motions. But I have, to say that I've had no communication with her, that I'm not communicating with her, I think is not fair analysis of the situation.
I didn't say there was no communication. I said the majority of my attempts at conversation with him are not being acknowledged.
Mr. Talmadge is the kind of attorney that I see at the jail on the weekends when I go in to sign probable cause affidavit. He's that kind of attorney. And so, if I grant you your request, you are likely going to be even more unhappy, depending on who is appointed, and especially if you hear the same exact thing. Additionally, the level of representation that you're asking for, unfortunately, that comes with, if you're willing to pay for that, you can have that. You can have an attorney that sits there and spends all day with you if you're willing to pay for that. But I don't think this rises at all to the level of ineffective assistance of counsel. It doesn't meet your needs and your very high bar, but that, I believe, you have to be able to pay for someone to explain this in the way that you're going to feel satisfied and understand.
No, Your Honor, with the conversation that Mr. Talmadge and I just had outside, he told me that he did not contact the two expert witnesses because he thought that my intention was something other than the purpose of him contacting those experts.
Well, and I don't wanna get too much into, your legal theory and things of that nature, those confidential communications.
Two of them are attorneys, Your Honor.
What's that?
Two of them are attorneys. One is a cannabis expert and one is an expert regarding DMV issues. That's why I asked Mr. Talmadge for 2 years now to please contact them and coordinate strategy. We have not even talked strategy, him and I.
So the level in which you're expecting Mr. Talmadge to act is one that I believe is, if you have the financial resources to back all that, I'll gladly let you go relieve Mr. Talmadge and let you hire an attorney that will go to the ends of the earth to make sure that, your case is heard. I can also, I don't necessarily wanna expose Mr. Talmadge to a threat of bar complaints against him. He's a valuable attorney on the consortium, and I want him to be able to, practice law in this community, and not have to worry about that conflict. So I'm more likely to grant your motion for him than I am for you, if that makes sense. So, and I know you're very patient, Mr. Talmadge. You're one of the most patient consortium, and we have good consortium attorneys. I'm not saying anything bad about them, but I am just saying that with you. So if Mr. Talmadge, if you would like me to go ahead and grant her motion, I will do that. I'll give her an opportunity at, one more attorney, and after that, she's on her own.
You know, Your Honor, I had the conversation with Ms. Graves out in the hallway. I guess I'll leave it up to her at this point. I mean, I told her that if it was really that important, I would talk to the other people. I will represent to the court that she initially provided an expert witness about a year ago, an attorney in Eugene, to talk about these issues. And I spoke to that attorney for about 1.5 hours. And we discussed all of these issues that she's raising, and he provided me with some information. And so I thought it was somewhat redundant. I also don't remember to the extent that she's saying that these people existed and as to what they would say, but I told her that I would be glad to contact these people if there's a postponement of this case. And I'm glad to set a hearing and have these motions heard. I don't think that they will be granted, that's my opinion, that's why I didn't file them, but, you know, reasonable people can disagree. I mean, other attorneys might file a motion like that, I don't know. And so I think that ultimately, if Ms. Graves needs to feel heard, then I would let her be heard on that issue. That's my deal. But if Ms. Graves is, I mean, she was very adamant in her last email to me that she felt that I was denying her appropriate representation, and if she's not comfortable with me going forward, I've shown her my work product that I've prepared for this trial, and I'm glad to let the court look at it in camera. I mean, it is extensive. I've put a lot of effort into.
Mr. Talmadge, I have no doubt, and that's why I said, if, I don't want to expose you, in regards to this case. So if, I need to allow that motion, I'll allow that motion, so it won't be exposed at all. So what would you like to do, Ms. Graves?
If the court's not willing to, what he's willing to do, I don't feel comfortable proceeding forward. I don't feel this is ready for trial.
That's not what this conversation is about right now. I
That's what
understand
I'm
that you're
saying.
not.
If he's saying to you, he's willing to do these things, now talk to the people I've asked him to, communicate with me, go over the strategy with me. If
Ms. Graves, I don't think you're going to be satisfied. I'm not asking Mr. Talmadge, I mean, he can do certain things, but if you think you're gonna walk out of here with him staying on the case and him jumping through all the hoops you want him to jump through, that's not going to happen, and that's not my expectation. He has legal knowledge and valuable experience, and so he uses that in making the decisions of what to put his energy to. He's not gonna leave here and do everything you ask him to do. I'm not gonna let him stay on the case with that expectation. I don't think you're hearing the court, and I don't think you're hearing Mr. Talmadge and the level of work that he's put into this. And that's frustrating. You've been given an attorney, you've been given a competent competent, very good attorney.
I-
And so you have a motion before this court, do you want me to go ahead and allow him to withdraw as your attorney?
Yes.
I will do that. You will be, are you asking to represent yourself?
I would like an attorney that is willing to communicate with me and strategize my defense with me.
Then you should, to the level in which you are asking, you may need to go hire your own attorney. I will go ahead and appoint you one, but we'll find ourselves right back here again, I guarantee you. Because what you're asking in regards to the level of service they can give, you need to go pay for. There's a limit. So, I'll go ahead and appoint another court-appointed attorney, but there's a limit into what they can do. And if you don't like those limits, then go hire an attorney. And that limit is a competent representation. Meaning that the court doesn't appoint an attorney and it go below that. I'm not saying that. But the level that you want, you need to hire your own attorney. All right, I'm gonna go ahead and continue the trial. I'm gonna go ahead and relieve Mr. Talmadge of his responsibility in this case. What should I do regarding who is appointed next?
I think we just randomly.
I think Ms. Collins would be the best person to answer that.
The next one on the list is, Missouri Clark.
All right. So you'll have Ms. Missouri Clark as your attorney. And then, in regards to motions, let's let Ms. Missouri Clark get familiar with the case and then see what she says about asking for a motion extension.
Yes, Judge. We set this for a DD court date in 2 weeks, and Ms. Missouri Clark can meet with Ms. Graves. We arranged and set motion deadline, so.
Yes.
Do we do court review this? Or
No,
any court?
any duty court is fine, but 2 weeks out, and so,
How far out do you want to do?
2 weeks?
I think 2 weeks is sufficient.
I can't hear you.
I think 2 weeks is sufficient.
Okay.
So we do October 4th at 1:15 is your next appearance. And so we'll give you contact information regarding Ms. Missouri Clark. And let me see what I can print out.
I can print it out for you.
That was October 4th, Your Honor.
Yes, thank you. Is there, oh, there is a,
And then her conditional release continues?
yes. I'm not seeing an order. Was there just a motion?
I have not filed the order, I'll file that today. I'll have Ms. Klein prepare the order when she gets back to the office.
Once you do that, I'll sign the order. Mr. Talmadge will not be your attorney. Ms. Missouri Clark will be your attorney. You're ordered to appear October 4th at 1:15. Thank you.
Good luck, Ms. Graves.
All right, so our next case then is one for pardon.
Lana? We're up.
to get some contact information, she just appointed me a new attorney.
Ms. Graves?
Oh,